Brent. Thank you, Miss Francine. Brent Allen Winters, commonlawyer.com. www.commonlawyer.com, coming to you, coming at you. Here you are over here, coming to you, coming at you from the remote hinterlands of the Wabash River Valley, where the hogs, the frogs, and the dogs keep up a racket all night long. Question 280. Stansbury's Catechism on the Constitution. Question. Suppose a slave, this is written back when there were slaves in some states, and not just the southern states, by the way, not just the southern states, no. There was slavery all over, and some of this, well, all the states permitted it, north and south, for a long time. 180. Suppose a slave in one state shall run away from his master and flee into another state. Does he thereby become free? Suppose a slave in one state shall run away from his master and go to a free state where their slavery is against the law. Does he thereby become free? Answer. That's 1828. Answer. No. On application of his master, his owner, and proof of his being his slave, he must be given up and returned. Now, that was the law. Why did they say that? Because the Constitution, our Constitution of the United States, demands it. That's why. And the principle of our Constitution that demanded it at that time was this. It's called the full faith and credit clause of our Constitution of the United States. Full faith and credit. The official acts of one state in one state shall be a sister state shall recognize as valid the official acts of another state. If the official judgment of another state in the court of that state says, yes, this is your slave, he takes that judgment and he goes to a court in a northern state where there is no slavery allowed and files that. Our Constitution, if we follow it, would say, well, yeah, the official decree in this state down here by a court, the court up here has to honor that decree as long as that court in that free state has proof that the court in the slave state indeed did decree that. We still deal with that today constantly. I've been in cases where people have brought judgments into a local court and said, well, a court up in Canada or a court out in the state of Washington, a foreign court, that's what we call them, foreign courts in these kinds of situations, whether it's a foreign country or a foreign state. The judgment and bring in proof of that judgment, a certified copy from the state where the judgment originated, file it in the court in ours. It's called enrollment of judgment. That's what we call it. You enroll it. You prove up to the court that it really happened in another state. Once you do that, our Constitution of the United States says the court in that state must honor it. Now, we had a situation in our neck of the woods. People, landowners, habitually would bring slaves across the Ohio River into Illinois and Indiana to work land, the farms they had. They'd come in the spring, and then they'd plow and plant, and then they'd stay there all through the summer. And then the slaves they brought there would harvest, and then the owner of the land in Illinois or Indiana would take the slaves back. That's southern Illinois and Indiana. They just come across the river. They'd take the slaves back into Kentucky or Tennessee or both. A little bit warmer, the winter's a little warmer, and they'd winter them down there and they could work them down there, see. Now, in some cases, the slave owners would, down in Kentucky or even in Missouri, they'd come across from Missouri, because the land in southern Indiana, along the north side of the Ohio River, And southern Illinois, going clean up to how far north you want to go for near, it was a lot richer. And I don't mean a little richer. I mean a lot richer. It was so rich. The land is so rich in those glacial till areas. Trees won't even grow on them. Of course, they couldn't raise tobacco there. They raised tobacco down in Kentucky because the soil is sandy and red clay. That doesn't work where the soil is not sandy and red clay. Tobacco won't grow. Not like it will down there. So they come up here and plant corn, barley, and oats, try to make money on the land up here in a different way. And they'd keep a caretaker who was a slave on the land in Illinois or Indiana. They'd keep a caretaker who was a slave. I was in a local courthouse. I went into the records office. That's that big room that's surrounded by steel plating in case the courthouse burns. It has records of marriage, birth, marriage, death, and land transfer. Key stuff. And in the Bible, they kept that kind of information in a box that was overlaid with gold inside and out. The land deed for the land Israel to the nation of Israel that the allodial landlord called the book of Deuteronomy was in there. A couple other pieces of evidence are a fact. Evidence is a fact. I kept in that box, and God said, don't touch it. I'll kill you. Yeah, he said, don't touch it. Why? That's the box of evidence. You don't tamper with evidence. That's how important it is, especially when it comes to land. Remember, all the land belonged to the allodial landlord. That's Yehovah himself. Well, I was in there working in that room where all those records were, and there was a fella in there with a camera, fancy camera, and he had this old piece of paper laid out. He'd gotten out of the records, and he was trying to snap pictures of it. I said, what you got there? Oh, he said, this is a court judgment that was filed in here for safekeeping. I said, how old is it? He said, oh, it's 1842 or something. I said, well, what are you interested in it for? He said, well, it's got Abraham Lincoln's name on it. He was the lawyer in the case. I said, what was he doing? He said he was defending a slaveholder who trying to get his slaves back. I said, no kidding. Let me see that. I looked down at it, said Abe Lincoln. And then Linder was for the the 5 slaves, a woman and 4 children. Her name was Mary Bryant, and her 4 children. Linder was a friend of Lincoln's. Linder was the attorney representing them on habeas corpus. They'd been taken into the county jail as runaways, and somebody filed a habeas corpus for them. A fellow named Doc Rutherford. He was a medical doctor in a little village there. He heard about it and he filed a petition for habeas corpus. Habeas corpus means we got the body. Hey, a petition means you're asking the court to order the jailer to bring the bodies of the jailed people forthwith in front of the judge, and the jailer prove that their jailing is lawful. And if he can't prove it on the spot, they're let loose on the spot. That's habeas corpus. I know you didn't know that. A lot of you. Why didn't you know that? You'd heard of it. But a lot of you didn't know what I just said, and some of you, it was new to you and you only caught part of it. Habeas corpus in our country, in our common law tradition, is called the writ of habeas corpus. Writ. What's a writ? That's something in writing. A writ, isn't that funny? A writ is something in writing. Remember that, well, one of the last movies John Wayne did, he played the part of a U.S. Marshal whose name was Rooster. Everybody called him Rooster because he was red-headed and arrogant. So they called him Rooster Cogburn. And there was a rat in this back room. He was living in the back room of a Chinaman's shop. And the Chinaman had all of his dry goods back there, including grain, and rats lived back in there. They were eating the grain. And he just finished supper and he's getting ready to take a snort to some whiskey he had confiscated from some people, from some men in the Indian Territory. And while he was sitting there getting ready to take a snort, he looked over and there was a rat getting ready to tear into a bag of grain. And he whips his 6-shooter out and he said, "Mr. Rat, I have a writ here that's writ for a rat. A rat writ for a rat that orders you to cease stealing grain forthwith," or something like that. "I'm a U.S. Marshal, bonded." And then he said to the gal who had come to see him, he said, "See, he doesn't pay no attention to me," and he shot him. Of course, if he'd have shot that rat with a 6-shooter, there wouldn't have been much left of the rat. But in the movie, the girl goes and picks the rat up by the table and throws it out to the tomcat, who obviously wasn't doing his job anyway. Or he wouldn't have had to try to do lawful service of a writ on a rat. I tell you that story just so you remember those words: a rat writ, writ for a rat. Well, what does writ mean? That means it's written for a rat. but in that case for a rat. But a writ is something that is a command. It's a common law term of art. It means a command in writing from somebody with authority to somebody else. A writ. Writ of habeas corpus is what is a command from a court to a jailer, says, "Bring the body of your prisoner by this name in front of me right now, or you're going to be held in contempt." That's why it's called the writ, because a writ is a command in writing from a greater, a court, to somebody that is brought into subjection, like the jailer. The writ of habeas corpus. Well, how do you get a court to issue a writ of habeas corpus to a jailer? Well, you file a petition. That's a request, requesting the court issue a writ of habeas corpus to the jailer. Well, Doc Rutherford did that. He heard that Mary Bryant and her 4 children were being held in jail to be returned to their owner, a fellow named Madsen. But Madsen, he couldn't find a lawyer, so he ended up hiring Abe Lincoln, who was in town at the time on the circuit passing through. That's what happened. Lincoln represented the slaveholder, and Linder, his buddy, represented the slaves. The argument was this: they're in a state that's not a slave state, doesn't allow slavery, and because they're here, should they be free? That's the free soil doctrine of our common law. The free soil doctrine of our common law says that our common law is the law of the land. That means that's another name for it, law of the land. It's in our Constitution of the United States, lifted out of Chapter 29, Magna Carta. No, not the Magna Carta, although I'm not opposed to saying that. But I always say Magna Carta because it's written in Latin, and Latin doesn't have a definite article, the, so it's just Magna Carta. Well, that's okay if you want to say the Magna Carta. As some of you know about me, I take particular delight in mispronouncing foreign words. I don't know how to pronounce them anyway. It's our prerogative as Americans. Well, habeas corpus, law of the land, that's what it is. And habeas corpus is called not just, there are many writs in our common law. There's the writ of mandamus, for example. You're requesting the court to issue a writ of mandamus. And there's other writs, but the writ of habeas corpus is called the great writ. It is the writ of all writs. And if the jailer's a rat, it's a writ for a rat. Now, if he's not a rat, he may just be trying to do his job or made a mistake, or that's okay. Until somebody complains with a petition for writ of habeas corpus, I suppose a lot of jailers just do their job. But when the court says, prove to me that this jailing is lawful, well, it's his job to do that. You see, that doesn't happen in the rest of the world. No, there is no writ of habeas corpus. You get your carcass thrown in jail, there's no telling whether anybody will remember you're there or not. I'm not exaggerating. I've been reading about the rape of Nanking. You know, the Japs went to Manchuria, they invaded, and they came to a city called Nanking. The reason they called it the rape of Nanking, they did a lot of other things besides rape the girls. They did that in mass. They also just stole everything, burned everything, took whatever they wanted. Well, they had invaded Korea before that. And the Koreans said, great, we want some protections to our freedom. That didn't happen. We did the same thing in Texas, like the writ of habeas corpus. Of course, they'd never heard of it until they heard the Americans had such a device. When Mexico won its independence from Spain, it was Spain. It was called New Spain, all of Mexico, a large area. Over half the United States was New Spain. Oh, yeah. All the Louisiana Purchase, which essentially most everything west of the Mississippi, not everything, but coming close, west of the Mississippi, Spain claimed rights to. They were just paper rights. They never acted on them. They never occupied the territory. And in God's book, you don't have it till your foot's on it. But they eventually, Mexico rebelled against Spain from, I believe it was 1810 to about 1821. And they won independence from Spain. And they said, we're going to have freedom like America. So we're going to put the Constitution of the United States to be our Constitution. We'll put it in Spanish. And their Constitution of 1824 was pretty much like ours. And they needed to populate the area where they'd just gotten. So they had a policy of Americans coming in. They called them the Anglos. But they had to come, and they said, we got this Constitution just like yours, and everything will be cool. You'll have all of the rights you had, like habeas corpus. Come here. So they came. The family came from right along the Wabash River. They were under contract with a fellow named Austin. You've heard of him. Moses Austin. He died, and then his son took over, and he's the one that became famous. And they had a contract with him, and he had an agreement with the Mexican government. And his people on Wabash here came down, called the Parker brothers, a couple of preachers. The first thing that threw them, they said, Mexico said, well, you can't establish a church here if you're preachers. You can't organize a Protestant church. It's got to be a Roman Catholic church. That should have given them a red light right there. Well, they beat that one. They didn't organize a Protestant church in Texas, which was part of Mexico. They organized the Protestant church up along the Wabash River, and they just moved it down there. See, they thought that was a technicality they could overcome, and they did. Well, things got worse. Here's what happened, essentially. Of course, the Parkers, you've heard me talk about them. Cynthia Ann was the daughter of one of those men, and the Comanche killed everybody, pretty near, except a few women and children, and kept them. And that daughter, Cynthia Ann, became the mother of the last war chief of the Comanche Nation, a fellow by the name of Juan Parker, who, by the way, took his mother's Christianity, and from that small beginning, Christianity went like wildfire through all of the North American Indian tribes, even up into Canada, and it's still there. The Christian adapted to some of the cultural won'ts of the Indian nation, the Sioux, the Hopi, the Navajo, all of them. It's become the most popular form of Christianity among the red men in America. That was Quanah Parker. But they promised those Texicans that they would have things like trial by jury, writ of habeas corpus, all the things we have in our common law, right to keep and bear arms. They had the Constitution of the United States, but it didn't work. Why not? Because it was contrary to their religious culture. Our Constitution of the United States is like Magna Carta, is absolutely head on, forehead to forehead clashing, contrary to the law of the city, the canon civil laws of Rome, the code of the Roman Emperor Justinian, that the Roman Church took as its canon laws, tweaked it to an ecclesiastic purpose. Also, the Greek Orthodox Church, every country in the world except the handful of common law countries. And they just couldn't make it work because, in their heart of hearts, in their deepest convictions, they were used to and wanted an emperor, an imperial tyrant. If you want an imperial tyrant in your religion that's a mere mortal or anything else, you'll never enjoy common law government and the freedoms therewith. Never. It can't happen. If there's a critical mass in America like that, we'll lose everything. And we've been fighting it for over 200, 300, 250, 300 years. Well, say no. Oh, pushing for, no. Over 400 years since people came here to escape that in an official way. The first people that came here were a sect of Anglicans, no, a sect of Puritans, which were a sect of Anglicans. They were all Anglican, called the Pilgrims. They came here for that reason, to escape that. The Code of Justinian, the Roman law, government by a single will. Well, that's what they had in Mexico. Had that constitution like ours written in Spanish, but they didn't have a clue what it meant. They couldn't make it work. It was impossible. They didn't even want to. It was foreign to them. What's a jury? What's the right to keep and bear arms? How about freedom of speech? Do we even know what that is? What is due process? That's our common law. Writ of habeas corpus? They never heard of that. Freedom of association? No. How can you govern a country when you allow people to say things against the guy in charge? Ain't going to happen, they say. Really? How do you govern a country with three separate and co-equal branches of government and none of the three are final on anything? How do you have a government? They couldn't comprehend that and didn't. And so therefore, of course, Texas revolted. And then they appealed to the United States to be brought into the Union. They were. We went to war with Mexico over it. You see, if two countries cannot agree on a common external standard whereby to govern their differences, they're going to kill each other sooner or later. Sooner or later, because the world is not big enough to accommodate countries like that. There's going to be a clash. Something's going to happen. Every war, that's why I say at the beginning of our presentations, every conflict, every war among men, between countries, is understood only one way: the law of the land and the law of the city, our common law tradition and the canon civil laws of Rome, Babylonian law. The only two traditions, fundamental traditions of religion, law, and government among mankind. There have never been any more than these two, under different labels. Never have been any more than these two, and never will be. And everybody or every nation is either moving more toward one or more toward the other on that continuum between the two. And they sometimes combine in the middle, that's true. But there isn't anything else. The law, our common law tradition, Christian tradition, with 2 volumes of law, the laws of nature unwritten, and the nature of creation, and the laws of nature's God written in the Bible. That's it. Well, it says, I was telling you the story about what happened to Lincoln. Of course, eventually, abject slavery is not compatible with our common law tradition. Our common law tradition has never held slavery to be lawful in all of its centuries of history. Oh, slavery existed where our common law tradition was practiced, like in the southern states and in the northern states at different times. But our common law doesn't allow it. It's against the law. And that inconsistency eventually came to a head in America. Involuntary servitude, slavery. Does it exist in our country today? Oh, yeah. Chain gangs, prisons, it's all slave labor at some point. Involuntary servitude. Lincoln lost the case, by the way. Linder, his buddy and opponent, argued, he was a lawyer there, argued the free soil doctrine of our common law. And he used as precedent a case of a slave from the state of Virginia. His master took a ship with him and they went to England. And when they got to England, the slave got rabbit feeling in his blood and he absconded. They found him and jailed him, and somebody filed a writ of habeas corpus. See, England's a common law country. There's a massive case in England that set a precedent, and Justice Mansfield said in England, he had looked high and low and couldn't find that slavery had ever existed at common law in the history of the island. And that's going back a couple thousand years. So, under the free soil doctrine, common law says that the soil that God has made is free, and if men live on it, they're to live free. Well, that's what the court ruled in the case of Mary Bryant and her 4 children in Illinois. Free. And turned them loose on the spot. And then Madsen, the slave owner, jumped on his mare and hightailed it across the Wabash River, headed back for Bourbon County, Kentucky. The reason he took off, here's the reason he took off. He didn't want to pay Lincoln. That's why he took off, and Lincoln never did get paid for that case. Now, here's the stupid thing about it. Listen, lawyers are the only people, and this is our common law tradition going back a few centuries. Lawyers are the only people lawfully can, if no arrangement is made between a lawyer and his client, the courts will hold that the client has to pay him before he performs his legal services. Why? Because all experience has shown in the history of our common law tradition that if a lawyer doesn't get paid up front, his chance of getting paid on the other end are slim to none. Is that true? Well, I can tell you for sure that's true. That's why people keep up a hatred of lawyers so they can justify not paying them. Oh, I know it costs a lot of money. Listen, if you don't have a lot of money, more money than people can afford, you can't get legal help. Well, whose fault is that? If a lawyer gives all of his time to the law, he got to make a living. And there are very few lawyers that don't work for the government that make a living. Did you know that? Very few lawyers that don't work for a government someplace that make a living. Very few lawyers in the private sector that make enough money to pay the rent and eat. Oh, there are some. I didn't say all, but most don't. No, they're looking for a judgeship or run for county attorney or work for the state government or the federal government. Because the hardest thing, I'm giving you a testimony, the most difficult thing about being a lawyer is getting paid. Anybody can look up the law. Shoot, that's easy. Given enough time, anybody can figure out the law. But to know how to operate in the courts, know how to operate in an evil, sinful world of sinful men like judges and other lawyers and your own self, coping with that. And then try to get somebody to pay you? You know, traditionally, I say that's why hookers demand money up front. They don't demand it after service is performed. Never have for thousands of years. They don't get paid either. Isn't it funny? Here's the funny thing. Who gets drawn to a hooker? Well, not the nicest guys in the world. Wouldn't you agree? And they're the ones that don't pay the bill, see? Who gets drawn to a lawyer? Well, just thinking through this a little bit. Is it the nicest guys or the brutal guys? If it's not the guys that aren't so nice, they don't pay either unless the lawyers get paid up front. I'm not drawing conclusions here. I've got my conclusions. I'm just throwing out the facts of the matter and some ideas. Well, he didn't pay Lincoln, and he hightailed across the Wabash and then down across the Ohio into southern Indiana, and he was gone. Lincoln threw his saddlebags up on his old gray mare he used to ride, and he took off for Cumberland County, a neighboring county, to see if there's any legal business there. But Lincoln understood habeas corpus. That was one of his earlier cases. But the time he became president of the United States, over 800, he as president of the United States received over 800 writs. That's a command in writing. 800 writs for habeas corpus because he had jailed, at his command, jailed over 800 people, many more who didn't ask for habeas corpus. He had jailed them, 800 writs, and he refused to comply with any court's order during that time on a writ of habeas corpus. Why? He said that the people he had jailed were out to destroy the Union and therefore were in a state of war, and our Constitution of the United States gives me power to suspend the writ of habeas corpus. Was that true? I don't think that's the doctrine. I think it's mushy. I don't think our Constitution says who has the power to suspend it. It does say that it may be suspended in times of war. It does say that. But who has the power to suspend it? You've got three separate and co-equal branches of government. Now, there are few views on that. One is only Congress has the power to suspend it. That's Justice Joseph Story of the United States Supreme Court. That was his opinion. Number two, the president, since he's commander in chief in time of war, he has power to suspend it. That's been the position, by the way, of George Bush and other presidents, Obama. I don't like that idea. And they suspended it and said that we can move people off American soil to Gitmo, and they no longer have rights that they can invoke for their protection. Well, that's not true. That was a damnable lie, and it's still a lie. I don't care what any president does. Moving a man out of the territorial bounds of the United States doesn't relieve the government of the United States from torturing people. Period. As Justice Joseph Story said, fundamental common law rights limit the actions of our general government in Washington, D.C., no matter where in the world on this globe they act, whether in a foreign country, whether in Gitmo, whether up here. Of course, Gitmo is the same as the United States. That's not a foreign country. That's land under control of the United States. United States land, territorial. Be like being in the back in the, well, I still say we have jurisdiction over the Panama Canal. I don't know. What's the matter with these presidents? Just give things up. I'm just going to give the Panama Canal to Panama. So Panama lets the Chinese come and take it over. Jimmy Carter for all of his education, didn't know Sikkim from come here. No, seriously, he didn't. A graduate of the United States Military Naval Academy. A man that's that lame in the mind had not been allowed to run for president. That was terrible. But he was such a nice guy, Wendy. Everybody loved him. Was he a nice guy? Oh, sure. He never said a mean word to anybody. You know, it was said that he had on his desk in the Oval Office, it was the most important thing in his life. He taped it on there with a piece of paper with tape, and it had boxes on it, and it was a schedule of who got to use the White House tennis courts. He was determined, above all things, to be fair to everybody on the White House staff. And he meticulously made sure that everybody was treated fairly and had their opportunity to use the tennis courts of the White House. That was more important to him, that he was fair to everybody there in the White House, than matters of state and the welfare of his country. That's a true story. Folk like that shouldn't be allowed in presidency. There are other kinds too. Then there are those like the Clintons who just treated everybody in the White House like dirt and did all the things Jimmy Carter did too. Is there any difference? I've talked to people that worked in the White House. They told me it was nothing but orgies and they mistreated everybody. Jack Kennedy, president of the United States, or at least was sitting in the White House. He didn't get voted in, as you know, cheated. He was nice to everybody in the White House. Oh, everybody, especially the female pages whom he was out to get in bed and was successful in doing so on more than one occasion. It was nothing but an orgy, like with Clinton. What did that do? Well, that fogged his brain real bad. He was too young anyway, but he didn't know what he was doing. He didn't understand matters of state. He didn't have the personality. Oh, he had the Harvard accent and the intellectualism, and he looked presidential and had a family and a wife, but he was just interested in getting laid. Just like Bill Clinton. He didn't care what went on. Well, if he did care, nothing he could do about it. He made the wrong decisions. He, of course, was of the same ilk as Roosevelt and Wilson. Just give the country away, let the commies have it. That was his attitude. What am I saying? Well, did they say, were they nice guys, a lot of them? Yeah. Did they say and do the right things? Oh, yeah. Kennedy wanted to put the greenbacks in place, and Jimmy Carter wanted peace in the world and tried to do it. That doesn't help. If you're right on all that, but you're selling the country into communism, what difference does it make? To quote Hillary Clinton about Benghazi, well, what difference does it make now? That was their attitude all along. They don't care how many Americans get killed. Well, we're back to this thing about the states and sovereignty, and we're struggling with it now. Do federal judges have power, authority that reaches nationwide? No. Question 81. How many states were there which revolted from Great Britain at the Revolution? 2 points. That's question. Miss Francine, that question 181. So we'll start on 182 next time. I'll address this one. Got a few minutes. How many states were there which revolted from Great Britain at the Revolution? I object to 2 words here: revolt and revolution. Revolt and revolution. There are a lot of revolutions in the world. Our war with Britain to separate from England, more properly, was not a revolt and it was not a revolution. It was not a revolt and it was not a revolution. Revolt and revolution are foundational to the law of the city. In modern times, the inventor of the modern form of revolution is the papacy. You've heard me say this. I say that on the authority of a law professor from Harvard who was forced out because of his conservatism. He finished up his career at Emory Law School in Georgia. He tried to pull all of his great learning together in one book toward the end of his life called Law and Revolution. Law and Revolution. And he traces the history of what we call the modern revolution, all the communist revolutions, the French Revolution, and a lot of other revolutions that aren't on our radar because they just aren't talked about that much. But they all, he says, and big thick book, he proves it. It arose out of what we call the papal revolution of the 11th century. That's when Rome officially took on the Code of Justinian of the Roman Empire as the canon law of the church. And if you want to know more about that, you can get my book, Excellence of the Common Law. I've got a whole section in there on how Rome took on that code. And by the way, then that became the chief vehicle for that code, that Roman code, to be the code of every country in the world. And today it is, except the handful of common law countries, which comes down to England and all of her colonies and former colonies, such as the United States, Australia, New Zealand, Tasmania, the Cook Islands, British Honduras, the Isle of Nevis in the Caribbean. Well, there are many of them. They're a little small, but the main ones are Australia, New Zealand, Canada, United States, all former colonies of Britain, of England, the British Empire. We're the common law. We're the common law countries. All the rest of the world are under some form of the Code of Justinian. And of course, the Roman Church and the Greek Orthodox Church are under that code. That's called the canon law of the Church of Rome. Incompatible with Magna Carta, incompatible with our common law tradition, incompatible with before Magna Carta, our common law tradition, wholly incompatible. Always has been, always will be. Why do I say that? Well, I'm not looking to make people happy. I'm doing all I can in my humble way to fulfill my responsibility to tell the truth about what I know and give my testimony about what I've learned. I don't know everything, but I haven't made it a point in my life for a few decades to make that my wheelhouse, and that's my wheelhouse is comparative law. There are a lot of men know more about it than me, and I'm indebted to them. Comparative law is a forgotten subject. It used to be taught and required in every law school in America. That's where I was introduced to it, in a big way, of course, but it is fundamental. If you don't have that in your wheelhouse a little bit, you'll be overtaken by the law of the city, as every country in the world has. That's what the devil wants. Controlled by a single will. Our separation from Britain was not a revolution. What was it? It was separation from Britain. We didn't attack them, they attacked us. We tried to defend ourselves. Don't you see that? Revolution attacks. You read our Declaration of 76, you won't get a hint of saber rattling in that anywhere. No place. No call to arms. No, we just said, look, we're separating from you because you're not allowing us to secure our future with our common law tradition. You're removing our common law tradition from us by infiltrating us with the law of the city, but you're being violent toward us too. You're inciting, I'm quoting, quoting the Declaration of 76, you're inciting the merciless Indian tribes against us, who have no distinction, make no distinction in their warfare between age, sex, or condition of infirmity. You give them whiskey, you give them guns. That's what it's talking about, and tell them to go kill Americans. And they were leaving the blood in the wintertime, coupled up with the Jesuit priest in Canada, leaving the blood red with snow in the American settlements in New England. Same thing was going on in the South. They were Britain was attacking our coast. They had a plan to infect the colonies with smallpox, wipe out the population. It was so clear that that's what they were going to do. Fascinating story of how we found out George Washington asked for the Continental Army at that time to submit to the smallpox vaccination. All of them did it, knowing that 10 to 15% of them likely would die because they didn't, in those days, know how to regulate the smallpox vaccination. That's a fascinating story how that turned out, too. He said they may wipe out the population of the country, but they're not going to wipe out my army. We're going to win. We're going to win, no matter what. They're attacking us. We must defend our homes. They're taking our. We're here to defend our land against enemies foreign. Coming across the Atlantic, that's foreign. And they came like they never came at anybody before. The most powerful army and navy military forces in the world at that time, best equipped, best trained. They came after us. And that was defense of our land against enemies foreign and defense of our land against enemies domestic. In other words, they were infiltrating us with the law of the city. They were doing away with the jury, the right to keep and bear arms. It's all in our Declaration of 76. So I'll end with this. We're going to, in our law school, we're going to teach a course on the Declaration of 76, clause by clause and blow by blow, clause by clause and blow by blow. And it is a comparative law exercise to do that, because what it says throughout is we object to you denying us this feature of our common law, right to trial by jury, this feature of our common law, separate and co-equal branches of government, this feature of our common law, the right to enter new lands, this feature of our common law, the right to be free from unreasonable searches and seizures, this feature of our common law, the right to be tried in the place pre-established by a boundary where the crime is to have occurred. Just as an example, we're going to go through those. It's all about our common law tradition. It's a companion to our Constitution of the United States, but it is our Constitution of the United States is a real case. Our Declaration of 76 is the real case and controversy that inflates the dry and dispirited words of our Constitution of the United States with real facts. And you cannot understand our Constitution of the United States until you have a real case and controversy to apply to it, or really apply the Constitution to the government. And that's what our Declaration of 76 is. Go to commonlawyer.com. Miss Francine, if you got a song for us, it'd be good. Go to commonlawyer.com and you can sign up for that class there. Appreciation of the donation. And when you do that, you keep us going, because we spend our time teaching. Primarily all we do now is teach. So I ask you to go sign up for that course and enjoy taking it with us. There are other courses there we've got in the can. You can sign up for those too. A course on trust law, a course on how to draft your own trust. Miss Francine and I are getting now, or I think it's in the works, the way I understand it, on the website, commonlawyer.com. Soon enough, there will be available a trust document, full-fledged, a product of a few decades of me drafting trust documents that you can use. As we used to say, plug and chug. Of course, I advise you, and I say this on the website, get legal counsel in your jurisdiction if you're going to do that. But I want that to be available. Well, commonlawyer.com, Brent Allen Winters.